Waiting for the first attorney to accept my request to turn their video on. Thank you very much, Mr. Axum. Having the second attorney turn their video on. Thank you very much. Let me tell IT we're ready to start. Judge Henderson, would you like me to open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3023, United States of America versus Deangelo Tyrone Jenkins, appellant. Mr. Axum for the appellant, Mr. Hansford for the appellee.
Mr. Axum, good morning.
Good morning. May it please the court. Tony Axum representing the appellant, Deangelo Jenkins, and I'd like to reserve 2 minutes for rebuttal argument. There was no probable cause to seize the Infiniti Deangelo Jenkins was driving on October 24th, 2017. There was no evidence that it was at the location of the shooting, and its mere presence in the vicinity and mere association with the crossfire shortly before shots were heard, and its mere presence and mere association with the crossfire many blocks away shortly after shots were heard, did not establish a basis for seizing the Infiniti. Under Ibarra v. Illinois and United States v. D. Ray, mere presence at the scene of a crime or mere association with someone who has committed a crime do not provide a basis for a search or seizure of property or person.
So let me ask you, Mr. Axum, so I'm clear on your position. You acknowledge that the police had the surveillance information and that witness 3 and 4 had provided certain information.
Yes, I do.
And you acknowledge, I believe, that the Infiniti SUV appeared to be the same Infiniti SUV that was in the video surveillance and referenced by the witnesses. Is that correct?
That is correct.
So at that point, in this hypothetical I'm asking, with that evidence, what do you think a police officer was authorized to do?
Well, I think
anything.
There may be, I guess I would need to clarify when you say that evidence. There is evidence that the Infiniti was seen at a certain location by, it was actually seen first at Firth Street in Southeast near Suitland Parkway. And it was next seen on Stanton Road in front of Turner Elementary. And then it was seen turning right onto Alabama. At that point, W3 does not claim that it sees the Infiniti with the crossfire any longer. And the crossfire is at 15th and Tanner Place, 15th Place and Tanner Streets. The W3 then also sees the crossfire at an alley across from the scene of the shooting. Again, not the Infiniti. The next time the crossfire is either picked up on a video pole, camera pole, or by W3 is at Stanton and Suitland Parkway. Now that is 5 to 6 blocks and then some distance from the scene of the shooting. So with those facts, with regard to the Infiniti, those facts don't even raise reasonable suspicion that the Infiniti was at this location of the shooting or had any involvement with the shooting. Now,
that's why I asked my question the way I did. Namely, a reasonable police officer, having looked at the surveillance, having read the witnesses' statements, could do nothing more than walk by when he saw the Infiniti and a man in it?
No, an officer can always engage a citizen on the street. There's nothing that stops a consensual encounter. There's nothing that stops an officer from talking and asking questions. There's nothing that stops an officer.
So in this case, the officer approached the Infiniti SUV.
I'm sorry, you broke up right as you in the middle of that question.
So in this case, the officers saw the Infiniti SUV
on October 24th.
and the passenger window was open. What did he say to the occupant in the driver's seat?
I believe that the officer said, "This vehicle, I'm seizing this vehicle." I believe the very first thing that the officer did was to seize the vehicle. So to I guess, return to your question as to what the officer.
I understand why you want to answer my question that way, but I thought the record was a little different. And maybe I'm wrong, but I thought the officer approached the vehicle and there was some conversation and the occupant refused to get out of the car. And I'm not clear here exactly what the officer did, but at some point, the officer put his hand through the open window and unlocked the car door.
I believe that's correct.
And then I'm not clear what happened to either. What, pull the occupant out, or the occupant got out when the police officer had unlocked the door?
I'm not sure that there's a dispute that the officer forcibly removed Mr. Jenkins from the car. So
after having asked him to exit the car 2 or 3 times? What I'm trying to establish here is the government's brief, as I recall, talks about the occupant's reactions to the officer's request to get out of the car.
Yes.
And puts this in part of the mosaic of what would a reasonable officer, having the information we've reviewed, do under these circumstances.
Well, what I would say is the officer did not have reasonable suspicion to seize Deangelo Jenkins. When the officer walked past Deangelo Jenkins, he only had information about the car. And I'd submit that information didn't, certainly not 52 days later, didn't rise to the level of reasonable suspicion to stop the car, but certainly not probable cause to seize the car. To back up just a little bit with regard to what happens on October 24th, the record evidence is that the detective, and this is from the affidavit, the detective conducted a traffic stop on the Infiniti and subsequently ID'd the driver. A traffic stop in and of itself is a seizure. And if it is a traffic stop, if the basis for the seizure is not conduct of a person, but because you believe you have a right to seize the car, then the seizure starts taking place once the officer stops the car. Now, with regard to Mr. Jenkins, if you're going to separate out the stop of Mr. Jenkins, which I'd submit you can't do when someone is in a car. At that point, there is no reasonable suspicion against Mr. Jenkins. There is only, I keep hesitating because I don't think there's reasonable suspicion to stop the car, but I'm not sure that there is a clear standard for seizing evidence. Either evidence is either seized, which requires probable cause, or it's not seized. There's not a standard of reasonable suspicion to seize evidence. There's a standard of reasonable suspicion to seize a person because the person is in the act of committing a crime or has recently committed a crime. And that's where the timing of this becomes a problem for the government too, because if the officers had reasonable suspicion with regard to the infinity is not a person. The infinity cannot commit a crime. So I'm at a loss for what they could do with that reasonable suspicion on the infinity. All they can do is seize the infinity, which then requires probable cause. So if they had reasonable suspicion for the infinity, they could not do anything with regard to Mr. Jenkins. They don't have reasonable suspicion for him. They don't have probable cause for him. But we do know, to return to October 24th, the first thing the officer says, and the record evidence is undisputed, is that he conducted a traffic stop. He didn't conduct a traffic stop of Mr. Jenkins and the car separately. He did both at the same time because of his suspicion about the car, which means that it had to be a seizure of the car when he initiated that stop. And any interaction with Mr. Jenkins was subsequent to that seizure and could not be a basis for justifying that seizure. So whether the officer reached into the car or not, whether Mr. Jenkins refused to get out or not, should not enter into the equation of whether there was probable cause to seize the car as the officer walked by. Now, if the court asks, like, what is a reasonable officer to do? A reasonable officer, as I said, could walk up to Mr. Jenkins and ask questions. This is not a situation of escalating suspicion on October 24th. This is a situation in which the officer from the beginning intended to seize the car. So the officer did not walk up and ask questions and did not do what we would call investigation. The officer immediately implicated Mr. Jenkins' Fourth Amendment rights and Mr. Jenkins' Fourth Amendment rights with regard to himself and with regard to his possession of the infinity. And if that all flowed through the infinity, then the officer needed probable cause to conduct a stop.
Well, Mr. Axum, from the officer's perspective, this vehicle was associated with another in a tandem driving arrangement that may or may not have involved them in the shooting, but gave rise to reason to, at least as you said, reasonable suspicion about the vehicle. But bear in mind that the crime in question here involved guns, involved the shooting. I'm not sure why that doesn't make an officer reasonably able to say that we've got cause to stop the vehicle and it's reasonable to be concerned about the individual as well.
Well, the first thing I'd say is that it's 52 days later, and
well, that was not part of any of your analysis. Well, you mentioned it once, but that's not key to your reconstruction of the sequence here of the events. You made an argument independent of the staleness argument.
I'm sorry, I don't follow you.
I thought you were making an argument about the precise sequence that unfolded here and whether there was probable cause or even reasonable suspicion, or at least reasonable suspicion at the time that the encounter began.
On October 24th.
Without regard to the 52 days, all right?
Well, I think it's difficult to, I have always incorporated the 52 days into this analysis.
Okay, all right.
I think it's difficult not to, because time is always a question. The reason in the reasonable suspicion, any reasonable suspicion case, that reasonable suspicion doesn't last forever, is obvious, because that's an expansion of the Fourth Amendment that is not found in the text or in any case law.
Is it reasonable to think that whomever is driving a car now was probably driving the same car at some earlier time?
No, that's not a reasonable assumption. It's not based in fact.
Isn't it
It's
based
a
in common
possible
experience?
it's a possible inference, but
I think I may have lost your sound.
no, I'm sorry. I'm sorry. The sound went out of me for a moment.
Oh.
But reasonable suspicion from its inception is an exception to the Fourth Amendment. In any time the Fourth Amendment is implicated, anytime your privacy rights are implicated, a warrant is required. But in Terry v. Ohio, the Supreme Court said that and a sense of urgency and exigency permeates Terry v. Ohio, because the officer at the time witnesses three, it may be four men, but at least some people casing business, and sees them walk back and forth 24 times.
But would you not agree that the Terry analysis has been applied in additional circumstances? And I thought what Judge Ginsburg was getting at was this notion that you have the surveillance information. And my initial question was premised sort of on the notion that it's the identical vehicle that's shown in the surveillance. So you say, well, he could go up and chat with the occupant, even if it's not reasonable to assume the occupant 52 days later is necessarily the same person. You have the traffic stop. The vehicle can be an instrumentality of a crime. You say he could talk to the person, and there, why not reasonably approach with caution, given that the crime involved guns, violent shootings, and maybe the occupant can provide some information to assist the officer in carrying out the investigation. And when the driver reacts the way he does, won't even get out of the car. Why isn't that enough to cause the officer's suspicions to be heightened?
Your Honor, I'm not saying that it's that the officer couldn't have suspicion.
No, my question is more than suspicion, heightened suspicion.
Well,
you know, we have all these cases about the prospective defendant acted nervously or didn't answer the questions directly. And that's been a part of the Fourth Amendment analysis. And I think you have to deal with it, don't you?
yes, certainly. All of this assumes, and if I'm forced to assume, if this is the hypothetical, and I'm forced to assume that the Infinity participated in the shooting, then yes, the officer would have reasonable suspicion. He would have heightened suspicion when he came up to the car if the defendant acted nervous. I'd submit that the seizure takes place, however, at the traffic stop. So the seizure has already occurred. And everything that flows after the seizure occurs cannot justify the seizure itself. So in claiming that the officer conducted a traffic stop, I understand the court's concern, but at that point, Mr. Jenkins has been stopped and the car has been seized. So any nervousness, any interactions with the officer can't be used as the basis to justify the seizure. The only thing that can be used as the basis to justify the seizure is what happened on September 2nd, 2017. And we know that on September 2nd, the Infiniti was with the Crossfire for a number of minutes during that day. At the crucial moments, the Infiniti...
All right, let me interrupt you. Judge
Yes.
Rogers, have you had your question answered, or can you continue it if we give him some reply?
I'm fine, thank you.
I would like 1 second, if I may, Judge Henderson.
Sure.
Seems to me that, Mr. Axum, you're ignoring, and we have not raised until now, the point that Mr. Jenkins' sister, if I remember correctly, had already told the police that he was the exclusive driver of that vehicle.
I understand.
So they
But-
now have the vehicle. They have the information that there's only one person who drives the vehicle. Does that change anything?
I'm not sure that before stopping the vehicle, that it adds to the equation that Mr. Jenkins was the person who could be stopped.
Well, the vehicle was involved in this tandem driving and maybe in a crime. And the vehicle's associated with only one driver. We can let it go at that.
Your Honor, I hate to argue this, but I'm having difficulty assuming it is an assumption that only one person drives it. She said she hadn't spoken to her brother in over a month. She said he was the driver of the vehicle, but that information, even if true, was not criminal. Driving a car is not criminal.
I understand that, but whatever suspicion attaches to the car now reasonably attaches to whomever is driving it, because we now have reason to believe that whomever is driving it is the same person who was driving it in the tandem driving incident.
Okay, so
That's all that was saying.
All right. Okay. Let me, we'll give you a couple minutes, Mr. Axum. Mr. Hansford. Good morning.
Good morning, and may it please the court, Eric Hansford for the United States. There are two alternative and independent grounds to affirm the district court's decision to deny the motion to suppress in this case. First, as we've been discussing this morning, the police had probable cause to seize the Infiniti. But second, any taint from the unlawful seizure dissipated by the time of the search, because the search was done under an independent search warrant that was executed in good faith.
Well, footnote 9 of your brief raises some questions about that. But let me ask you, where in your brief do you discuss the traffic stop?
I'm sorry, the traffic stop meaning what occurs during the course of the traffic stop?
Nope, the traffic stop itself.
The fact that there was a traffic stop and what would justify that?
And what,
I believe.
where is that discussed in your brief?
So I think that's in footnote 2, but I think before we get there, that is not properly before the court. The defendant below never.
Properly before the court.
The defendant, it's forfeited because the defendant below never objected to consideration of the traffic stop before the district court. And indeed, in his own motion to suppress evidence discussed the course of that traffic stop with no suggestion that there was anything problematic about the traffic stop or that anything would be subject to suppression. And the motion to suppress specifically says he's moving to suppress the 2 guns and to suppress the buckle warrant. And that's it. And so the district court, there was no argument below that the district court should be precluded from considering any of the evidence learned during the course of the traffic stop. And indeed, during the course of the proceedings, both parties were discussing it. And I think there are other points that seem to be trying to be reopened on appeal that are important to note, which is that defense counsel below expressly conceded, this is on appendix page 140, said, "I concede that these vehicles appear to be traveling together." So any suggestion that it's mere happenstance that they happen to be in the same area, that's an express concession that was made below. And the district court, I think, properly relied on the full scope of the evidence that was in the affidavits. And what the district court says is this is on appendix 179, the parties don't dispute the material facts that are relevant to the defendant's motion. These facts are contained in the affidavits, plural, that were submitted by both the defendant and the government. And so the question before this court at this point is whether the full facts in those affidavits would support probable cause, not whether certain facts can be knocked out on a kind of theory that there wasn't reasonable articulable suspicion. I will say as well on the traffic stop, I think we also discussed this in footnote 7 of our brief. It is not clear, the police approach a parked car. They stop behind a parked car. And it is not clear if there's actually a seizure at that point because it's not litigated below. But the defendant is clearly not, even though there's a show of force, the defendant is not agreeing to that show of force. And so under Hadari D, there is not a seizure until the defendant actually yields to that show of force. And so we don't have anything in the record suggesting, the record's unclear, I'd say, but I think that has to count against the defendant, given that he didn't raise these issues below. I do want to also note, in addition to this tandem driving, this 8-minute, 3.5-mile loop around the crime scene, the police did have at least one other crucial piece of evidence before the encounter with the defendant on October 24th, which was that they had tracked down the crossfire, and the crossfire showed multiple bullet strikes in the crossfire. So in other words, this car that they had tracked down, and license plate readers did identify these 2 particular cars. But these cars that the detectives had tracked down in this case, the first car that they tracked down on suspicion of being involved in the shooting, it did show signs of being involved in some shooting. And so that provided further corroboration that these 2 cars that they noticed making this unusual loop were indeed the cars rightly seen as subject of suspicion in this case. I think and I do think under Wesby, it's important to consider the full totality of the evidence that was before the district court. So the fact that there may be an innocent explanation for something, the fact that it's not illegal for the defendant to be driving this particular car. Wesby says the question's not whether there's an innocent explanation. It's not whether a single fact in isolation is going to provide probable cause. It's looking at the full totality of the circumstances, and often individual facts that may on their own not seem particularly significant when viewed as a whole with the rest of the evidence, that does create probable cause. We do, in addition, make the argument that even if there's not probable cause in this case, the independent search warrant that the police obtained dissipates any taint from the seizure of the Infiniti. And I think this case presents a scenario that's a lot more common in the context of buildings and homes where the police do commonly obtain warrants, but it does apply equally to cars, which is that the police plan to get a warrant to search a place, but in order to maintain the status quo while getting the warrant, they enter without a warrant and secure the premises. And what Murray and Segura and others say is, as long as the police were going to get a warrant anyway, the independent source doctrine dissipates the taint from any illegal entry or seizure. And that's exactly what happened here, which is that the police seized the car, didn't use anything that they saw during the course of the seizure, and then obtained an independent warrant based on that. And our brief on pages 46 to 47 cites a number of cases in other circuits that have applied similar reasoning in the context.
9 acknowledges that the affidavit relied on the defendant's statement that he was homeless.
That's right. The affidavit does include that statement. We think that
the police learned from the first encounter.
So that is something that the police learned from the first encounter, but we don't think that flows from the seizure of the car. At most, we think that flows from a temporary, reasonable, articulable suspicion seizure of the defendant as part of this traffic stop. The defendant is not arrested on scene, and the Supreme Court in Hensley, a 1985 case that we cite in the footnote 2, says when the police have reasonable, articulable suspicion that someone has been involved in a completed felony, the police can temporarily seize that person as part of a traffic stop to investigate that suspicion. So we think the police at least did have that. And in any event, I think that the statement that the defendant was homeless is not the kind of straw that pushed us over into. There's no reason to think that is the reason that the magistrate granted the warrant. And the background principle is that the police should not be in a better position from an illegal action, but they also shouldn't be in a worse position, which the Supreme Court explained in Murray. And so there's no rule that they have to kind of scrub any illegal action from a warrant in order for the independent source doctrine to apply. We think that kind of single statement buried at the end of the warrant would not be enough to defeat the independent source doctrine. If there are no other questions, we would ask that this court affirm.
All right, thank you. Mr. Axon, why don't you take 2 minutes?
Thank you, Your Honor. I'd respectfully disagree with the government that the independent source doctrine does not require that it allows for something to be scrubbed from the affidavit. The independent source doctrine does not say that. None of the cases say that you simply excise the improper information from the search warrant or the affidavit and then consider the affidavit anew. The cases actually say that the warrant itself must be wholly unrelated or wholly unconnected to the stop, to the seizure. They could not, the case law could not be more clear. So as we lay out in our brief, the independent source doctrine and attenuation doctrines don't apply in this case, primarily because the police needed an independent legal basis to seize the Infiniti, separate from the information contained in the search warrant. And here we know that from the beginning, the police seized the Infiniti in order to search it. This is just the type of exploratory investigatory work that the Fourth Amendment prohibits. If the police could have gotten a search warrant ahead of time, then they should have gotten a search warrant ahead of time. They should have had a search warrant as the officer was walking down the street and saw the car, as the officer was pulling up in his car and stopped the car. With regard to the government's claim that below we conceded that the cars were traveling together, that's at page 140 of the appendix. And it is not the only statement that Mr. Venegas, who was representing Mr. Jenkins below, made with regard to what he was agreeing to in this case. But he says, yes, Your Honor, because the video surveillance is clear and the police are able to time it, and I would have no reason to dispute it based on the fact that they have poll cameras at the school and then they have poll cameras leading into the parkway. Given that, then I'm not going to challenge the timing of it. So I can see that these vehicles appear to be traveling together. He links the vehicles traveling together with time, but he doesn't say the vehicles are together the entire time. We know from W3 that W3 sees the crossfire at the location closest to the shooting and sees the crossfire directly across the street from the shooting. I would also point out to the court that within the affidavit, the first affidavit itself, as W3 enters Suitland Parkway, it sees the crossfire behind it. It does not see the Infiniti with the crossfire behind it as it enters Suitland Parkway. On Suitland Parkway, at Stanton and Suitland Parkway, there is a poll camera that captures the crossfire and the Infiniti. The crossfire, again, the first affidavit indicates that the crossfire is driving and the Infiniti accelerates. And the next indication in the affidavit is that the Infiniti is at Firth Avenue and Suitland Parkway 1 minute before the crossfire arrives at that location. So the affidavit is actually out of sequence, but the affidavit does say that the crossfire accelerates, if you look at the timestamps, after the Infiniti has accelerated. But the only time there is acceleration is on Suitland Parkway, blocks and blocks away from this shooting. And that is the second time that the Infiniti is seen at all with the crossfire by W3. So it is simply not accurate. It is not accurate, as I laid out in my briefs, that the cars were looping this area together. And it is simply not accurate that they fled the direct scene of a shooting. It is accurate that they drove fast.
Let me stop you. If there are no more questions, you are way over your time. All right, the case is submitted. Please call the next case.
Case number 19-7106 et al., LLC SPC Stileks versus the Republic of Moldova, appellants. Mr. Grasso for the appellant, Mr. Bird for the appellee.
Mr. Grasso, good morning.
Good morning, Judge. Good morning, Judge Rogers, Judge Ginsburg, Judge Henderson. I really hate to do this, but would it be okay to take a 2-minute bathroom break?
Well, we're on a very tight schedule right now. I guess we'd better let you.
I really appreciate it. I will be right back. Thank you very much.
Ann? Ann, are you there? Is it possible we could, the judges could have some privacy for the next few minutes?
Yes, just give me 1 minute, Judge. I can put everybody in the waiting room. I will need about 1 minute. I can confirm when everybody is in the waiting room.
Judge Henderson, is that okay?
That's fine. That's perfect.
Thank you.
All right, Mr. Grasso, proceed.
Thank you very much. I apologize. I was entranced by the previous case. May it please the court. Good morning, Judge Rogers, Judge Ginsburg, and Judge Henderson. I must start by saying that it is an honor to be arguing before this court today, even under these circumstances that we have to do it virtually. Because of the ongoing pandemic, it's a little bit weird. I think that it deprives us of a dynamic that we would normally have.
Mr. Grasso, would you please get to this case?
Absolutely. So the facts underlying this case are extremely complicated. They're 20 years in the making. It has a very complicated procedural history. The facts of this case are not illustrious. They're not sexy. But the legal issue and the precedent that may be set by this court is of potentially historical magnitude. And that is because this case involves the interpretation of statutes that codify international law and thereby impact the entire world, just as the ongoing pandemic is. As this case with all matters of this nature is before this court, one of the planet's most prestigious courts, the implications of this precedent cannot be ignored, and they will have an unpredictable trickle-down effect for the duration of human existence.
So let's talk about your argument as to why you contend the district court abused its discretion in lifting the stay.
Okay. So in terms of the district court lifting the stay, I think that it was done prematurely because of the ongoing proceedings in Europe. And that is currently the crux of the issue before the court today, and which is why I implore the court to reserve judgment pending the outcome of the highest court in Europe.
So when you argued to the district court,
I'm sorry?
When you argued to the district court,
I didn't.
When an attorney on behalf of your client argued to the district court that lifting the stay would be premature, he referenced or she referenced both what had happened at the Paris Court of Appeals and subsequently the referral to the European Court.
Yes.
The record shows as well that the district court was aware that your client was contesting the jurisdiction of the tribunal to proceed.
That is correct. My client has always contended that the tribunal did not have jurisdiction under the ECF.
The district court took the position, as I understand it, that the only matter remaining was not jurisdiction, but whether public interest.
I'm sorry, Judge, you just broke up before public interest.
The district court took the position that in light of what had happened, by the time the matter was before him, the only remaining issue was not jurisdiction, but public interest. Is that correct?
That's my understanding, Judge, yes.
Was that accurate?
I don't believe so. It depends on how you would define public interest, which I think is part of the issue that is before this court today.
Well, do you consider it to be a jurisdictional issue?
I think that this court can decide to consider it a jurisdictional issue, yes.
Well, do you have any cases that that's how this court has viewed the public interest standard?
Well, I think that as to public interest specifically, I do not have any cases, no. However, I think that the most on-point case as to that question is actually the case that was most recently introduced by counsel for the appellee, which was recently decided by this court in process. And it was in that case, I'm sorry, where the court went out of its way to stress the importance of affording almost every reasonable inference to a foreign sovereign.
Well, Mr. Grasso, let me focus you more directly, okay? Sure. Because in your reply brief, you state that appellee has not addressed the argument that you're making.
This was the supplemental brief.
In my record, it's the reply brief in this court.
As far as process goes, it was only
No.
I'm sorry, we're
In
missing
the reply brief,
okay.
You say that appellee deliberately ignored Moldova's argument.
Yes.
That the Paris Court of Appeals had stayed the remand proceeding and transferred the matter to the Court of Justice.
That's correct.
Is there anything in the record that indicates under French law the award nevertheless is to be enforced?
Well, Your Honor, with all due respect, I'm not familiar with French law. However,
well, I asked you in the record.
I believe that there is, because
Where?
Because in the record, it's in the record very clearly that there is currently a case pending before the highest court in Paris. So I think that it is an open question. I don't think that that question of law has been settled.
So the answer to my question is no?
I think that the answer to your question is yes.
And
Because
there is evidence in the record that the award can be enforced notwithstanding these jurisdictional appeals?
well, that I think is a different question, and that I would have to answer no to.
Grasso, I was under the impression that nobody notified the district judge before he lifted the stay order that the court in Paris had referred the matter to the European Court of Justice a few weeks before. Is there any indication on the record that the district judge was informed of that?
Not that I am aware of.
No, and I couldn't find it either. So it seems to me that Moldova dropped the ball here in not informing the district judge about the reference, but regardless of that, that it's out of bounds for you to be arguing the reference to the European Court of Justice when it wasn't put before the district court. Although it did occur in time before he lifted the stay order, about 3 weeks difference.
That's correct, which is in large part why I'm arguing it. Also because I don't believe that this case should be viewed in a vacuum. I think that there are much broader implications in this matter, and that this court does have the power to decide in accordance with its previous decisions and the decisions such as process, to the extent that the language and process constituted stare decisis, that there was no waiver of sovereign immunity by the Republic of Moldova in this matter, and that the appellee's argument does not hold water in that respect, and that this court should therefore reserve judgment because it's always been the policy of the United States to defer these cases to the sovereigns that may be more familiar with cultures that we don't understand, different politics, different jurisprudence.
Judge Ginsburg.
Nothing further. Thank you.
All right, Judge Rogers.
Yes, I have a question. Going back to my first question,
Yes.
what were the jurisdictional arguments that your client made to the tribunal, to the Paris Court of Appeals?
Well, Your Honor, my client never agreed that the treaty, that the ECT, the Energy Charter Treaty, applied to the arbitration, and thereby invoking the arbitration exception here under 28 United States Code 1605(2)(6), which is one of the appellee's primary arguments. And that was one of their main arguments before the tribunal.
Did they make another jurisdictional argument?
I believe so. That the New York Convention did not apply either.
And what did the Paris Court of Appeals hold?
Well, the Paris Court of Appeals, I believe, remanded the case.
What I'm focusing on is it specifically said it was not going to address other issues. It said, right?
The Paris Court of Appeals?
Yeah.
I don't know that
No?
that language was specifically used.
Well, the briefs don't tell me either. But when it got up, when the case got before the Court of Cassation, I'm not sure how to pronounce it,
Yeah.
the highest court in France,
Yes.
it said the Paris court had mistakenly added a requirement that was not in the treaty, but that the court itself, the highest court, was not going to address other issues. Sent the case back to the Paris Court of Appeals to start all over.
I don't believe to start all over, Your Honor. I believe that the purpose was because to lift the stay and
No, it was the Paris Court of Appeals that said it was going to start all over before it certified the matter to the European Court.
okay.
That's not an okay answer. I mean, is that correct?
Well, so our interpretation is that the Paris Court of Appeals simply chose not to follow the instructions of the French Court of Cassation, and did decide to reopen all of the appellate issues. And this includes the issues which we were just talking about, referring to the tribunal's findings regarding the arbitration award, and my client's issues with the award to begin with, on the merits of that case. And this is a substantial issue, and there's a lot of money involved between two foreign parties. And I think that it boils down to the fact that I just don't think that it belongs in this court.
I think we understand that's your argument. I'm trying to flesh out what's the basis for that argument.
Okay. So obviously this case has a very complicated procedural history. And part of the basis of my argument is the fact that there's such a complicated procedural history because of the action of foreign courts, of which we can't even pronounce the names of. I think that in and of itself says something about the reservation of judgment in this matter.
The fact that my French is not perfect is not going to help you.
Well, I would also state that in Chevron, as was argued in the briefs, the Court of Appeals stated that if there was no arbitration award to be enforced, that the district court would lack jurisdiction over a foreign sovereign, and that the action must be dismissed. I think that the facts here are more knowledgeable to Chevron, and that the underlying logic of all of these cases, the underlying rationale, the underlying policy is stagnant throughout. And that there is an entire body of law that is much broader than the body of law that carves out these narrow exceptions to the New York Convention, to the Foreign Sovereign Immunities Act, and to all of these laws that we have since 1976 that only were implemented because, as things go, different issues arise in the courts involving foreign parties, and it needs to be dealt with by the legislature. Now here we are, and we are discussing and arguing about procedure and purely procedural issues that have no bearing on the facts of the case or the merits of the case that are best decided elsewhere.
Judge Rogers, has he answered your question?
I'm fine.
All right, Judge Ginsburg.
Nothing further, thank you.
All right.
Thank you.
Mr. Byrd. Mr. Byrd.
Oh, yes. Good morning. May it please the court. My name is Gene Byrd, and I'm representing Stileks, the appellee in this matter. Unfortunately, in 2 days, we will be commemorating a very important date. That's 7 years since the tribunal in Paris issued an award, almost $60 million in favor of the predecessor of Stileks, the company named Energo Alliance. For 7 years, Moldova resisted enforcement of the awards through various court proceedings in which it participated or which it initiated. Even here in Washington, D.C., in the district court, Moldova initially did not even bother to retain a counsel and spend time of the district court to raise all various defenses that the counsel, which for Moldova, who entered representation several years after the petition was filed in the district court, even tried to try to turn back the time and try to file its defense all anew, which district court, of course, denied. The question that was discussed here before is abuse of discretion. The abuse of whether the district court abused its discretion, and Judge Rogers was absolutely properly asked where did the district court abuse its discretion, because this is the standard to deny, to grant, or to reverse a decision of the district court, to grant or deny stay under the in the petition proceedings under the New York Convention. And yes,
that an abuse of discretion can arise both where there is an error of law or a clear error of fact, correct?
that is my understanding. Yes, Your Honor.
All right. So my question is, and I'm just looking for it in the record to point you directly to the district court statement. When the district court described his understanding of the case that was before him, did he accurately describe it?
I believe so, Your Honor. And the district court pointed out that the cassation court, that's my understanding how it's pronounced, but the cassation, it's, of course, the cassation, yes. The highest court in France, they set aside or reversed the Court of Appeals. That was the moment when the award became valid and binding again, and when it sent the court, when the cassation court sent the case back to the Court of Appeals, that is since that moment of time the award became valid and binding. So there is no indication on the record that presently the award is not valid and binding.
Well, I looked at your expert's statement that's in the record, and he does make a general statement to the effect that if there's an award and there's no stay, then the award is immediately enforceable. What I did not see, and you can tell me if I missed this, was any explication that that is the rule under Paris law when the threshold question is jurisdiction of the tribunal to proceed at all, is challenging the award. In other words, as you know, in this country, just because you get a judgment from the district court doesn't mean it's necessarily enforceable, either because someone appeals or they raise a jurisdictional argument. So when the district court was describing this, he says, as to the stay, there are two questions. The first one is, what is the status of the 2013 arbitral award? All right. And then he references the statement you made. And then he goes to the URCAL factors. And he says, quote, citing Eurocar, that in many countries, an arbitration award is final, binding, and enforceable, even if subject to appeal in court. I'm not questioning that statement, but I'm trying to understand if that's also true in the jurisdictional context that's been at issue here from the very beginning, and that went up to the Paris Court of Appeals and up to the Court of Cassation. And that court's ruling was limited in the sense that it said that the Paris Court of Appeals had mistakenly added a requirement that the treaty did not require. in terms of what is an investment and sent it back to the Paris court. But that's as far as it went. Is that your understanding?
Well, my understanding, Your Honor, is that there is no distinction, at least from the cassation court decision, whether there is between the jurisdictional issue that was brought in the arbitration, in the arbitral proceeding, the jurisdiction of the arbitral tribunal. These are all issues that are brought up together to the Court of Appeals, whether the award is valid, and the Court of Appeal decides on all of the issues that are brought up by the petitioner. And then all of these issues all issues together that are brought up to the Court of Cassation, and the Cassation Court reviews all the issues and then decides on whatever issues the Court of Cassation decides to decide. And based on its decision, the Court of Cassation sends the case back to the Court of Appeals. Court of Appeals, in turn, says...
No, I'm not disagreeing with that general statement. But what I'm trying to understand is your understanding. If a party is arguing the original tribunal had no jurisdiction under the treaty, and that issue goes up, and the highest court in France says, well, and these are my words, obviously not the court, there are a lot of issues in this case. Some of them are jurisdictional, some of them aren't. But at least as to how the Paris Court of Appeals defined an investment, it added a factor that was error. So we're sending it back to the we're sending this matter back to the Paris Court of Appeals. When the case gets to the district court, and tell me if this is a correct reading or not, appears to think that the jurisdictional issue has been resolved. And the only remaining question, basically under the New York Convention, is whether enforcement of the award would be contrary to international public interest.
I'm not sure that would be my understanding, Your Honor.
All right. So what is your understanding?
Well, my understanding is that the district court did not address that. The district court was fully aware that the issue of the tribunal's jurisdiction has not been resolved. I believe that's clear from the district court's assessment, because the district court was well aware that this is the issue that was brought up in the Paris Court of Appeals. That is the issue that was brought up before the Cassation Court. That is the still issue that is being resolved. And the district court knew that, was aware of that, and considered all the balancing Eurocar factors. And based on this balancing, the district court said, enough is enough. 7 years is enough.
Here's what the district court said, and this is at the appendix 318. It said, talking about the third factor under the Euro.
I'm sorry, it's appellants at the A3?
A318.
Thank you.
See the paragraph talking about the third factor?
Almost there. Sorry.
No, it's fine.
The third factor. Yes, it's in front of me. Yes, Your Honor.
Good. Okay. So if you scroll down, the district court says, moreover, you see that sentence?
Yes.
It says, the Cour de Cassation. How do you pronounce it?
Cour de Cassation.
3 syllables or 4?
3.
All right. Has already concluded that one of Moldova's arguments for setting aside the award, that the ad hoc tribunal lacked jurisdiction, is without merit, leaving just the argument that the arbitral award is contrary to public policy for consideration. This reduces the likelihood that the arbitral award will be set aside and thus counsels in favor of lifting the stay. End of quote. So my question is this an accurate statement, essentially that the public policy is the only remaining issue? And if it's not, then doesn't this reflect, or does it reflect, a fundamental misunderstanding of the status of the proceedings, which is what the district court said it had to determine? And that is so even, as Judge Ginsburg noted, Moldova did not mention the referral to the European court before the judge decided to lift the stay.
Well, Your Honor, regardless of this statement of how this court understood the Europcar factors do not even take into account the likelihood whether the award will or will not be set aside by the court, but by the court in the foreign jurisdiction. The factor is the comparative level of scrutiny that the arbitral award will receive in the French system. That's the correct statement in the first sentence of that paragraph on A.318. I believe that would be the key factor, regardless whether how the judge understood the decision of the Court de Cassation.
Well, if he misunderstood that, why would it follow that he could count this factor as weighing slightly in favor of lifting the stay? If in fact, regardless of the level of scrutiny, the jurisdictional matter is in fact still in dispute.
Well, the jurisdictional matter was in dispute from the get-go. That we don't deny that. The question is the balancing of the factors, because this is not only one factor.
Okay, you don't deny it, but he was under the impression that it was no longer in dispute. But I have another question closely related to this. Did Moldova ever argue about this?
I don't believe so. I don't believe that Moldova brought this up.
Okay.
So we do have a doctrine that the court can, citing Supreme Court decisions, address a matter that goes to the heart of the case, where Moldova challenged the jurisdiction, never surrendered that challenge. The highest court in France has yet to rule on that. And yet, in determining whether or not to lift a stay, the district court proceeds on the assumption that the jurisdictional matter has been resolved as a matter of French law.
Well, Your Honor, this is just only one of the factors. There are multiple factors, and this is the court discretion. This court never ruled, or at least my understanding, my recollection is this court never ruled that the district court ever abused discretion, would be abuse of a discretion standard in lifting or granting a stay. So regardless of the understanding of the court de cassation, of the district court's court de cassation decision, there are other factors to consider as well.
All right, so your point then, and I'll ask counsel for appellant about this, is that appellant never argued there was an abuse of discretion, merely that it was premature.
That is correct, Your Honor. Yes.
So in arguing it was premature, was not Moldova saying, although I grant you it's not in haec verba, it's premature because the question of jurisdiction is still at issue, being litigated?
Well, I believe that what Moldova argued is that generally there are proceedings in foreign countries that are ongoing, and there was no indication that they specifically argued just because the jurisdictional issue is still allegedly at issue in foreign proceedings, then this should be the stay should be granted. And moreover,
Say that again for me, so I'm very clear on what your position is.
What my position is that the general statement, the general argument of Moldova, that there are, which is what they made, that there are foreign court proceedings that are ongoing, never pointed out to specific jurisdictional issues. That it's just something that Moldova waived.
But what I'm trying to get at is that was the district court understood it had raised the jurisdictional question, but it understood that was resolved. And you don't think it's a fair understanding of the argument that it's premature to lift the stay because there are these pending proceedings on the question of jurisdiction of the tribunal? And yeah, excuse me, go ahead.
My understanding, Your Honor, is that it's a general argument that Moldova makes a general argument that there are pending proceedings, and the court was very well aware of this pending proceedings, and nothing was hidden from the court. So regardless which issue was before the court, specifically, whether it's jurisdictional issue or public policy or other issues, the court will aware that there's an ongoing proceedings which may in fact take more years to decide, because the European Court of Justice does not simply issue a decision on the merits. It only issues an advisory. That's what my understanding. It only issues an advisory decision on the on the issue of the convention of the Energy Charter Party that goes back to the Paris Court of Appeals, and then Court of Appeals may decide whatever they may decide, and then it goes up to may go up to the Court of Cassation. It may as well take 3, 4, 5, 6, 7 years more and that's what the district court was aware of.
My only question would be then, you may be right, that even if the district court understood that it had misunderstood that the jurisdictional issue had been resolved, it may still have decided that it was going to lift the stay. But why wouldn't this court want to remand that question to the district court to correct its understanding of of the fundamental issue in the case? Because the district court was proceeding on the premise that jurisdiction had been decided. Now, if he understood that jurisdiction was still an open question, he might decide to deny the motion to lift the stay, or he might decide to lift the stay. But from reading the record, I can't tell what he would do. I mean, there's no question this is an old matter. The contracts are 20 years old, that arbitration is a slow process, a costly process, not the speedy, inexpensive arbitration notion that was entertained by the Supreme Court in the early days. I mean, the international treaties and conventions have changed the nature of arbitration. And I think the hesitancy here, and I just want to be clear on your position on that, I agree that this is only one of several factors for the district court to consider. But if it's the fundamental issue in the case, why wouldn't we want to be sure that the district court wants to proceed, particularly when from the very beginning, the Paris court in the dissent by the chief judge pointed out that this question, I mean, to the extent Moldova says our decision may have extraordinary implications, so too may whatever the French courts do on remand, much less what the European court does in defining what is an investment under this treaty. That's the only question I have.
Your Honor, may I address that?
Of course.
Yes. What I'd like to say is that the standard is abuse of discretion, that regardless whether this understanding of the district court, whether it was misunderstanding or correct understanding, that does not rise to the abuse of discretion standard that is required for this court to overrule the district court, to send it back. So that is, and in the general understanding of the district court, that the proceedings are still ongoing, and that regardless whether it's jurisdictional issues or some other issues, these are that was absolutely correct understanding of a district court. The district court took into account in making this decision.
Thank you.
All right, Judge Ginsburg.
Oh, thank you.
All right. Mr. Grasso, you can have 2 minutes.
Thank you very much, Judge Henderson. I would just like to point out the circular nature of Appelli's arguments, especially given Judge Rogers' comment about the treaties that we now have that have changed the game in terms of arbitration, which I agree with. And one of the relevant treaties here is the United Nations Treaty on Commissions and International Trade Law. And when you take that treaty along with the ECT, it and Moldova's position that it never agreed to the arbitration, then it can't be argued that the issue of arbitration can be decided by the district court. So again, going to the heart of the issue, as pointed out by Judge Rogers, of jurisdiction and what the district court knew and didn't know, what they would have done, what they, under different, hypothetically, under circumstances which none of us here can predict, and circumstances that are beyond our ken to a great extent, just for inherent reasons. I think that it's the most prudent thing to do for this court to reserve judgment.
So let me ask you, counsel, can you point me in the record to where Moldova argued before the district court that there were pending proceedings And they were addressing, among other things, the jurisdiction of the tribunal under the treaty. And if you can't do it now off the top of your head, I would ask that you submitted a letter to the court with my colleagues, subject to my colleagues' agreement.
Can you answer it now?
For the sake of being thorough, I'd prefer to submit a letter to the court, so that I don't miss anything, because the only thing that I can think of off the top of my head, I don't think is as a clear-cut answer as Judge Rogers may be looking for.
All right, Judge Rogers, could you restate what you want him to research?
Where in the record did Moldova identify for the district court that the pending proceedings involved, among other things, the question of the jurisdiction of the tribunal under the treaty?
Understood. I will submit that in a letter to the court. When would you like that by?
Judge Henderson, be guided by you.
How about 5 days? And
I was thinking
Byrd.
12:30 today.
Yeah. And Mr. Byrd, you can have 2 days to respond to that. All right. Any more questions, Judge Rogers, Judge Ginsburg?
No, thank you, Judge Henderson.
All right. Your case is submitted.
Thank you, Your Honors. It's been an honor.
This honorable court is now adjourned until Monday, October 26th at 9:30 a.m.